On the one hand, digital technologies are amplifying sort of like our fundamental rights, and on the other hand, of course, they are magnifying the possibility of dominant actors to compress these fundamental rights. So I think that we are living a constitutional moment, and I think that we can define a constitutional moment as a moment of change in the constitutional ecosystem. Our constitutions were drafted for an analog world. There are a couple of legal philosophers, Philip Allott and Norberto Bobbio, who say that essentially, and explain very well, that constitutions are the fruit of a specific time. Rights emerge as a result of specific needs of the society. And I think that today we are witnessing something which is very similar. So the society, of course, is challenged by the digital revolution. We have new needs, and at the same time, the constitutional ecosystem that was created for societies of previous generations is struggling to address the challenges that we are living today. And for this reason, we are witnessing the emergence of new norms, but before that, actually, the emergence of conversations on which norms to adopt to face the challenges of the digital revolution. And actually, this emergence of new conversations is what prompted me to write these two books, Digital Constitutionalism, The Role of Internet Bills of Rights, and The Content Governance Dilemma. So these two works actually focus on discourses that are emerging not always in the legal context, but also beyond the law, but that do have a normative content. So they are trying to address the question, okay, what are the norms, what are the principles that we should adopt from a constitutional perspective to address the challenges of the digital revolution. And there was this expression, constitutional moment, to mark a period of intense debate and discussion about sort of like which norms, which principles we should adopt. So I think the current constitutional moment, at least in the digital field, is marking this era of societal reflection. There are a multiplicity of actors that are involved, and not only institutional political actors, but also very much the civil society. And this is actually one of the topics that I was exploring in these two works, that are contributing to shape how we want the legal framework to be like in order to face these challenges. So the traditional legal perspective merely looks at legal actors and legal sources. There is this Austrian legal thinker, Kelsen, who describes the legal sources as structured in a rigid pyramid. So at the top we have the Grundnorm, the Constitution, and from this basic norm essentially all the other sources acquire their own recognition, legitimacy. But of course it's a closed set of sources. Well, today I think that if we adopt a socio-legal approach, so if we start sort of like asking the question of what are really, like factually, the normative sources that are addressing the problems that we are living, we have to go beyond sort of like the traditional set of legal sources. So this is why today we are observing that the state is no longer alone in setting the standards, the rules for the digital society. We also have powerful dominant actors just besides nation states, and some of them are multinational companies. This is actually not a novelty. This also occurred in the past. We can see at the sort of like history there were very powerful private organization, for example the Dutch East India Company, that sort of like ruled in a quasi sort of like as a state in the past. That an army could create coins, could sort of like trade and declare wars. And today we can observe something similar as regards sort of like major multinational tech companies. They have the power to sort of like set standards that go beyond national borders. States and state law always lags behind. Of course, these multinational companies set standards for entire sort of like regions or parts of the world that of course transcend national boundaries. And at the same time, they do these internal private rules, so what we could call has been called by the scholarship, the Lex Facebook or the Lex Digitalis, just to sort of like reuse the metaphor or the expression of the so-called Lex Mercatoria, was the law of the merchants. So they can affect fundamental rights. So this is why I think that it was very helpful for me actually to look at these actors, because I think that they're really shaping the way in which individuals can enjoy their fundamental rights. So today, so in the past actually, sort of like states had the power to compress or potentially to violate fundamental rights of the individuals, and constitutions, national constitutions, were actually set to limit the possibility of dominant actors, which at the time were only like state actors, to compress fundamental rights. But today this possibility is also in the hands of private actors. They have this capability of determining to what extent, for instance, we can exercise our freedom of expression online, the extent to which we can access information online, the extent to which we can associate in a sort of like a virtual context, and all the other sort of like a series of related rights. So this is why I think that it's extremely important to look at the rules that these actors are setting, not only from a substantive point of view, but also from a procedural point of view. It's extremely important to understand how are these actors setting these rules. Of course, in a very different way from the methods that are used in sort of like contemporary democracies. These are private actors, so they set rules unilaterally. There is no sort of like a politics behind, there is no democracy, there is no participation behind the sort of like creation of these rules. So my first task was actually to try to define what the constitutional field traditionally covered. So I looked at sort of like scholarship, various sources, and then I pretty much liked actually a definition that is included in a very old constitutional instrument, that is the Declaration of the Rights of the Man and the Citizen of 1789. So one of the sort of like seminal documents that were created during the French Revolutions. And there is particularly an article, Article 16, that in a very succinct but robust way says that a state has no constitution if the protection of fundamental rights and the separation of powers are protected. So in a nutshell, we could say that the traditional objective of constitutions was to protect fundamental rights and at the same time to maintain a status of equilibrium between the various powers. So I decided actually to adopt this framework to look at how the digital revolution is currently affecting the constitutional ecosystem. So essentially I observed and I tried to categorize the effects of the digital revolution on the constitutional ecosystem, and observed that we are currently witnessing a sort of like a twofold Janus-phased phenomenon. On the one hand, digital technologies are amplifying sort of like our fundamental rights, and on the other hand, of course, they are magnifying the possibility of dominant actors to compress these fundamental rights. Very often today in sort of like media, but also legal discourses, we are very much sort of like focusing on the negative sort of like aspects of the digital revolution. So the extent to which actually our fundamental rights are compressed in the digital society. But there is also, of course, this sort of like positive connotation as well. Starting from these two main categories, I decided to look at how actually in sort of like digital technology is affecting in a positive way the two fundamental core aspects of sort of like the constitutional instruments, so the protection of fundamental rights and the separation of powers. So what we can observe today is actually that digital technology can amplify the possibility of individuals to protect fundamental rights, and of course this is apparent, and this is why I was making a series of examples. I think that, for example, freedom of expression is apparent that today is one of the rights that has become more horizontally accessible to individuals. It was not possible before the advent of digital technology that everyone could freely express for free at sort of like a very significant scale their own sort of like opinion and beliefs. And of course, like rotating around the principle of freedom of expression, there are also another set of fundamental rights. It might be the freedom of religion, the freedom of conscience, freedom of assembly, that of course are based on the principle of freedom of expression. At the same time, the digital technologies are also helping reinforcing the position of the individuals vis-a-vis the power of dominant actors. So today we could say states and also private multinational tech companies. So in this way, digital technology is also helping rebalance the sort of like asymmetry of power between dominant actors and the individuals. So the fact that, for instance, today we can access government information online, we know what is going on, for example, or we should, in our own sort of like political process. There is a right to access information held by the government. This helps sort of like reduce this informational gap between individuals and government. Then in terms of sort of like a negative aspect, of course, I mean, we could make lots of examples, but the fact that over the past few years there have been so many discussions about compression of the right to privacy. This is only one of the sort of like many examples that unfortunately we can provide related to the possibility of digital technology to compress our fundamental rights and therefore to affect the constitutional ecosystem. So this is why we have a series of counteractions, what I call counteractions, that are emerging actually to readdress this status of equilibrium. And this is in relation to sort of like the protection of fundamental rights, but also in relation to the balancing of powers. We can see that unfortunately digital technology can also be used by dominant actors to even reinforce their condition of power vis-a-vis individuals. So if we think of, for example, state surveillance, that very often is sold by state actors as necessary in the context of global terrorism and crime where we're living, at the same time might have as a counter effect sort of like a pervasive control of individuals and of course a series of unintended consequences from a societal perspective. I think that we need a constitutional conversation or even a series of constitutional conversations, plural, on which rights and principles we need to address the challenges of the digital revolution. We are experiencing a moment where if we look at our currently existing constitutional instruments, yes, they might be interpreted by lawyers, legal scholars, judges, but I think that common individuals cannot understand in a very explicit way what are constitutional principles and values and rights are in the digital society. I think that what we should aim for is actually a series of rules that are clear, that are directly focusing on the problems that we are living. So in order to reach that status, we need a sort of like a conversation where a plurality of actors participate. We can no longer sort of like foresee the traditional process of constitution making that was done in the past with a few very often like male individuals like closed in a sort of like a big meeting room drafting a constitution. Today what we should from a normative point of view probably hope for is a more participatory process of constitution making where all the societal sectors can contribute to shape actually the rights and principles that we want to see respected in the digital age. The right to internet access is particularly interesting because it's a right that allows individuals to access other rights. So it also plays this sort of like ancillary, if you want, or instrumental function as a sort of like a gatekeeper to other rights. There are a series of problems when it comes to formulating the right to internet access. So the first question is, what is the internet? So of course we use this term, but what the internet means today is we might have sort of like a series of ideas. Actually in this book, Digital Constitutionalism, the Role of Internet Bills of Rights, I try to do also sort of like an empirical investigation looking at sort of like existing definitions of the term internet and looking at how sort of like a civil society was sort of like describing the context where they would like actually these new rights to be. And surprisingly, we can see that there is no univocal definition of what this context that we sort of like we call the internet is. And I think this is apparent, especially today, if you look at like new emerging technologies that of course make the headlines. Today we read every day about like generative AI and all these sort of like related technologies, and I think that sort of like the world of digital technologies is rapidly emerging. So this is one issue related to the formulation of a right to internet access, but there is also a problem from sort of like the entitlements that would derive from affirming a right to internet access, in particular in relation to the instruments that individuals should have access to in order to benefit from this right. I'm speaking of, for example, connectivity, broadband. So today we don't have a right to free connectivity. We all sort of like pay for connectivity. Of course, there are sort of like areas where sort of like broadband is free. Think of like universities, some like public spaces, but of course not everyone has access to connectivity, and especially good and fast connectivity. I'm thinking especially of like rural areas. And second, of course, devices. This has been apparent also in a sort of like academic context during the pandemic. We thought that everyone would have access to a decent laptop, a decent connection, but this was not the case. Many of our students actually struggled to sort of like follow our lectures online, and these I think highlighted really well some of the issues related to the right to internet access. There is also another consideration which I think is particularly interesting. I think that now there is also a conversation on which internet we want to have access to. So is an internet that is based on a model of multi-stakeholder governance? Is an internet that is safe for everyone? Is an internet that is inspired by specific values? So in a certain way, we could say that what we're witnessing today is a conversation on a fundamental right to access a specific right, a specific internet, a specific place that online, a virtual space that we could call very generally the internet. Digital literacy is one of the main challenges that we are living today, as the right to internet access is one of the sort of like basis, preliminary assumption that should be in place in order to allow individuals to access and benefit from their digital rights today. Digital literacy is also a field where most of the supranational and international organizations are working at the moment in conjunction with the national and local governments. Everyone, since sort of like their childhood, should have sort of like a basic education about digital skills, the risks that are associated to the use of digital technologies, and I think that it's essential in order to have sort of like a society that in the future will be able to benefit from digital rights, to have a well-educated society from this point of view as well. Today, states struggle to enforce our fundamental rights online. As I said earlier, our legal rules were shaped for the analog societies of the past, so very often we don't have, from a legal perspective, a norm that reflects the current status of technological development. So even for public actors, for law enforcement authorities, sometimes it's difficult actually to take a norm and apply it actually in the context that we are living, because there is a work of interpretation that is involved. So there is a first dimension. Second dimension is the dimension related to the enforcement. We are speaking of virtual spaces that transcend national boundaries. There are problems related to jurisdictions. There are problems related to actions that are physically performed in other nations that might have effect in other countries. So all these series of issues make the life of traditional sort of like state agencies, police and so on, very difficult. So this is why actually private tech companies have intervened, because they had this space that was in some cases they were directly delegated by the state, and progressively we can see an emergence of a series of pieces of legislation that are trying actually to make private actors more responsible for the content, for instance, that is published on their platforms. At the same time, this was a sort of like a vacuum, an empty space that was left by the states, and where these private companies therefore intervened. The big challenge that we are witnessing today is to make sure that the action of these private actors is in line with our own sort of like a constitutional values and principles. Of course, private actors, their objective are very different from the objectives of state actors. They don't have the sort of like a public good in mind, but of course, as all sort of like private organization, profit is their main driver. So what we should do from a constitutional point of view is try to instill constitutional oriented values and principles into their private norms. The sort of like a combination, the partnership between private and public actors, I think this will be the key solution in order to face the challenges that we are witnessing today. The metaphor of the Middle Ages has been used very often in the characterization of private tech corporations today. So we can observe that these companies are acting in a way which is very similar to the way in which sort of like feudal sovereigns of the past were acting. So they are essentially, they can govern in an almost unlimited and free way within their own private virtual fiefs. And the challenge for state actors and for the law is actually to intervene into their sort of like private rules and try to make sure that the rules are in line with constitutional principles, but also the way in which they administer justice within their private fiefs. So the way in which they are acting as judges of these private virtual worlds is in line with constitutional norms. And this, of course, is extremely challenging. There are a series of issues related to the scale of this phenomenon. So the fact that sort of like states relinquished this function to private actors because cases related, for instance, making the example of like social media content governance, we witness the emergence of hundreds of thousands of cases every hour, every day. So this would be impossible for national courts to deal with this amount of cases. And also, actually, for private companies, this is a challenge, and this is why actually they resort to processes of automated decision making. So they employ algorithm, AI, in order to detect content that, for example, violates their own internal rules. So it's extremely important, and this is a sort of like twofold challenge that these constitutional principles that were sort of like drafted for past societies are today revisited, translated. I really like this term, like this work of like translation that we should do to keep the sort of like DNA of constitutional principles of the past, but we should make them sort of like work and speak to the societal actors of today. And we should instill this principle within the code, sort of like the infrastructure, sort of like this mechanical, algorithmic mechanism that these companies are using. And at the same time, this should also inform sort of like the human portion of decisions that are taken by these actors. Private companies should not be left alone in this, so there should be a guidance from sort of like state actors, and this guidance actually can be provided by means of legislation, can be provided by means of sort of like checking of by national authorities of a series of like reports that are done by these private actors. And in this direction, most of the recent pieces of legislation adopted at EU level, this is the direction that they are pursuing. But also a fundamental role, we mentioned earlier, digital literacy is also played by individuals, by users. It's very important that every user of these platforms becomes aware of their entitlement, their affordances, the fact that, for example, everyone has a right to appeal decisions taken by these private actors. And only in this way we could develop a culture of safety, a culture of fundamental rights, of constitutionality also in the virtual environment. There are multiple ways of regulating actions in the virtual context, and they're not different from the existing ways of regulating human behavior in the physical context. We could make the example of sort of like physical enforcement in the sort of like in the physical world. So for instance, when you in order to limit speed on roads, sometimes we can see that the sort of like we put some ramps, in order to limit the speeds of like vehicles. In the same way, actually there is a possibility to limit actions, of course, in the virtual world, which is even amplified by the fact that we act through technology. This is a big possibility that we have, both from sort of like state perspective, but also from the perspective of these private platforms to regulate human behavior and the actions online. So there is this twofold process that probably should be put in place. So we should, as a sort of like legal scholars, law and policymakers, better understand how the code is working, how the technology is working, in order to provide private companies with more guidelines on how to instill, how to incorporate constitutional rules within the code. And this is one of the sort of like fundamental ways of enforcing fundamental rights online, on top, of course, of the possibility of enacting laws, discussing principles and rights. But the two should necessarily go together. It's completely useless actually to enact the most perfect and nicest digital constitution of the world if we don't understand actually how to implement these rules in the code, in the infrastructure of technology. Internet Bills of Rights are declarations that are seeking to articulate rights and principles for the digital society. Most of the legal scholarship has so far neglected the value of Internet Bills of Rights because most of them are non-legally binding. So they are adopted by civil society actors, they are adopted by ad hoc committees at parliamentary level, but they do not possess legally binding value. However, I think that I decided to study the emergence of these Internet Bills of Rights because I think that this phenomenon is extremely interesting from a constitutional perspective. So first of all, because of their scale, we can observe that in the past decade, hundreds of declarations of digital rights have been adopted and published. And secondly, because they all adopt a constitutional language, so they try to use the same terms, the same expressions that are used in traditional constitutional text. One of my main questions in this work, Digital Constitutionalism, the role of Internet Bills of Rights, was exactly, okay, but what are these documents trying to tell the sort of like constitutional law scholar? And this is why I decided to use this metaphor of the litmus test. So if you want, as in chemistry, the litmus test can be used to measure the pH of a liquid. The Internet Bills of Rights can be considered as a sort of like health test for the status of our constitutional ecosystem. So the fact that so many actors, so many individuals are contributing at the moment to the conversation on which principles, which rights we should adopt to face the challenges of the digital revolution, make us understand that maybe these principles, these rights, as they are formulated at the moment in existing constitutional instruments, are not clear, because otherwise, why to adopt all these declarations? So I thought that even if their emergence lies outside the classical, traditional field of study of the legal scholar, it was extremely interesting to understand what this phenomenon is trying to tell the legal scholar. And what I can observe is that this is an alarm sign. So in my book, I use the expression constitutional anemia to denote this status of disorientation, if you want, of societal actors, that if they open their own national constitutions, they cannot find principles that explicitly address the problems that the digital society is posing. So this is why I think that globally, comprehensively studied Internet Bills of Rights are extremely interesting sources because they are telling us what is not working in the constitutional ecosystem, aspects where more conversation is needed, principles that where more work is needed in order to better craft it, in order to speak more directly to the digital society. So this is why I think that analyzing Internet Bills of Rights also, and especially from a multidisciplinary perspective, can really help us understand where we are going and especially where we want to go. In 2021, we decided to start a project focusing on content governance. We thought that social media are acquiring an extremely important role from a constitutional perspective. They do play a constitutional function, as I said earlier, both from a positive perspective and from a negative perspective. They're a vehicle to foster fundamental rights, and at the same time it's a dangerous place for individuals where fundamental rights can be easily compressed and violated. So together with some colleagues, we decided actually to use the same methodology of analyzing digital Internet Bills of Rights and understand what civil society, all these actors that are adopting this text are saying about content governance. We decided to call this book The Content Governance Dilemma because we are currently witnessing this hard choice that platforms have to make between, on the one hand, adopting national rules The problem is that if we adopt national rules, we have to make a choice. So some individuals would be subject actually to rules that are not the rules and the values of their own sort of like a country. There is the choice of adopting international law rules. So this is actually the option that is mostly advocated by NGOs, civil society groups. But at the same time, we try to demonstrate that from a legal perspective, international law is very general. It is not granular enough to address the specific issues, the specific problems of social media platforms. The other option was to resort to the internal rules of private platforms. There, of course, the major critique is that they are unilaterally set, they can be unilateral and at any moment changed by the platforms without transparency, without democracy, with scarce legitimacy. So we tried actually to understand how digital bills of rights can contribute to solve this dilemma. Eventually, sort of like the terms of service of major social media platforms are the sort of like the decalogue of rules that govern the life of the platforms. So this is essential that these companies progressively try to understand how to incorporate these rights and principles into their rules. We cannot leave corporations alone. We cannot believe in self-regulation anymore. I think that investing in digital literacy on the one hand, investing in adapting existing normative sort of like instruments and rules at state and supranational level is essential in order to really like foster a conversation in order to understand how to better address these problems. I think that each part of this triangle should be aware that alone they cannot solve these issues.